Good morning, everyone. Our first case today for argument is Sanchez versus El Milagro, number 24-3250. Ms. Barr.
Good morning, Your Honors, and may it please the Court. Whitney Barr on behalf of Appellant Alma Sanchez. This case is about textbook sexual harassment. Ms. Sanchez works the night shift at El Milagro, a tortilla factory. In the summer of 2020, her coworker, Francisco Gutierrez, groped her buttocks on 3 separate occasions. First, Gutierrez came up behind her, pressed his penis into her buttocks, and rubbed his genitals against her.
Ms. Barr, can you tell me which case is most factually analogous to this, in which a court has held that the harassment, similar to what occurred in this case, was severe and pervasive enough to constitute sexual harassment?
There are a
for
few,
you?
sorry, Your Honor.
Go ahead.
There are a few cases that I believe are applicable and most analogous here. First would be Patton, and the other case would be Worth. And in those cases, there was a single touch of an intimate body part. And if we look here,
But what was the intimate body part in those cases?
in Worth, it was the plaintiff's breast. In Patton,
Was it underclothing or overclothing?
it was under clothing.
That's a big difference. But what was the other one?
The other one was Patton, and the harasser had reached up underneath the individual's shorts and touched her upper thigh. But whether or not there's clothing does not mean...
What was the frequency in patent?
In Patton, it just happened once. There was one single touch of an intimate body part, and same with Worth. Whereas here, there's multiple instances of physical contact with an intimate body part. And starting with the first time she was groped, Gutierrez pressed his penis into her buttocks and rubbed his genitals against her.
And Ms. Barr, are there any cases that address a factual situation like that, where it's not only the intimate body part of the person receiving the harassment, but it's also involved the intimate body part of the person that's allegedly harassing?
No, what happened in this case far surpasses any conduct that this court's ever qualified as non-severe. This was an intimate body part making contact with another intimate body part. And this court's repeatedly recognized that direct contact with an intimate body part is among the most severe forms of sexual harassment. This court's deemed the outer boundary of non-severe to be a single poke to the buttocks. That's the principle that I believe decides this case. If a one-time poke is at that outer edge, then genital rubbing against an intimate body part cannot plausibly be anything other than severe. But if that one grope that Ms. Sanchez endured isn't enough, then the 3 times that happened combined surely are enough to constitute a severe or pervasive hostile work environment. This wasn't just a pat on the arm or a squeeze of the shoulder. This court's never found...
Are you going to address employer liability here?
Yes.
Because I just have some questions about that as well. It sounds like the first time it happened, she told her supervisor. Second time it happened, she told her supervisor. Third time it happened, she told the supervisor in HR. HR conducted an investigation. HR interviewed her and him with he said, she said situation. HR said, we don't believe her, basically. We believe him. And nonetheless, they sent him a letter reprimand. It never happened again. What's the basis for holding the employer liable under those facts?
The standard for liability for sexual harassment is either failure to discover or remedy the harassment. And El Milagro was on notice of the harassment after the very first time Ms. Sanchez complained about it.
I agree with that. But you have to agree that the very first time, one incident where he says it never happened and she said it did, that could not constitute severe and pervasive. You know, somebody walking by somebody else and their genitals touching their buttocks and saying that I don't think that would qualify on its own as severe and pervasive harassment under our case law, would it?
Maybe not alone, but certainly when construing the record in her favor, it would. When you look at what actually happened, he didn't just brush his genitals up against Ms. Sanchez. He came up behind her and intentionally rubbed his genitals against her. But the point is, the employer was on notice of this genital rubbing because her supervisor was this designated channel to put the company on notice, and he did not follow
I agree with
the
that.
sexual harassment policy. So that's where the liability starts, is that El Milagro failed to discover it because their own supervisor, who they purportedly trained to escalate these complaints to human resources, did not follow that policy. And then it shows how egregious the failure was, because then he did it again. He came up and touched her buttocks again, and then
What
again.
was the employer supposed to do here? It sounds like your client is complaining that she was not promoted. That's what it sounds like to me from your brief, that she was not moved to a more favorable shift or a more favorable department. In other words, she complained of harassment, and the employer conducts an investigation, finds that she's not telling the truth, essentially. But the brief, it seems like to me, and what you're suggesting is that the remedy that the employer should have engaged in was to move her to a more favorable shift or a more favorable department. How can we write an opinion that says when someone complains of sexual harassment, the remedy is for the employer to separate the individuals, which necessarily may mean moving one to a more favorable shift, a more favorable department, or promoting one of them?
Well, certainly.
What is the employer to do here?
I think separating the two is the minimum that the employer should be.
And how would
responsible
this
for.
employer do that?
Well, there were 2 other shifts at El Milagro, and I don't think either of those are more favorable. In fact, Ms. Sanchez prefers a night shift so she can take care of her children during the day. And there were also 3 other production facilities.
And if she would have been moved, if she preferred the night shift and she would have been moved off the night shift, then she would have sued for retaliation. So this is the question: what is El Milagro supposed to do here? I mean, what would they do?
Well, I think that's a question of reasonableness, which is a question for the jury. And at this stage, the threshold question is whether it was even severe or pervasive harassment to begin with. But I believe a reasonable jury could find that they issued this token letter of discipline and just assumed that it didn't happen.
Why is it a token letter of discipline? Once the letter was issued, harassment, she never complained of harassment ever again. Why is that a token letter?
The law asks whether, at the time, given the circumstances, the employer's response was reasonable.
But the employer didn't believe her. So again, what were they supposed to do? They conducted an investigation. They concluded that she was not telling the truth. They didn't believe her. Were they supposed to fire Gutierrez nonetheless?
Well, in Bakersville, this court held that when the harassment amounts to a physical assault, then a reasonable response would be immediate termination.
But they said it didn't. That's the whole point is they have to conduct. We're not the employer, okay? We're not a super personnel department. They conducted the investigation. They found it was not credible. But nonetheless, they reprimanded Gutierrez, and it never happened again. They basically told him, stay away from her, which apparently he did.
A reasonable jury could find that the actual investigation was inadequate, though. As you mentioned, Your Honor, they interviewed her and him, and that's it. She putting her word against his. And HR
Did
concluded,
she suggest that there were any witnesses to what happened?
not that she was aware of, but that's the whole point. HR concluded that the harassment just didn't happen because there would have been witnesses and they would have seen what would have happened. But HR didn't even go to interview any witnesses, didn't even attempt to seek out. A reasonable jury could find that that was negligent on El Milagro's behalf.
Again, what is the standard we're supposed to write in the opinion? That when an employee complains of harassment and doesn't identify witnesses, the employer is required to post a bulletin in the break room that says, did anybody see this alleged harassment? And if so, let us know so we can interview you. I mean, what are they supposed to do?
I think they do. I think they go down to the production floor and ask if anyone
What
else
case
saw it.
law supports that?
I think this is an issue for the jury, Your Honor.
What law says that that is an issue for the jury?
Reasonableness is a question for the jury.
So that means that every single one of these cases goes to the jury under your test.
Well, only if it passes the initial threshold of being severe or pervasive. In this
Well,
case,
wait a minute. It's got to pass also, it's got to be severe and persuasive, and there has to be a basis for holding the employer liable, right?
certainly. But here we just have the first question. The court ruled.
Oh, no, we can affirm summary judgment on any ground. The district judge, Judge Hunt, didn't address the second ground because she found that it was not severe or pervasive. But we could skip right over that and affirm based on, there's no basis for employer liability.
I think The first basis for employer liability is the fact that their own supervisor, who's purportedly trained to escalate these complaints, did not do that, and that is a failure on the company's behalf.
Ms. Barr, I think that kind of unpacking this a little bit, let's assume that for the purposes of argument today, that we disagree with you with regard to whether or not the employer's investigation and response was reasonable, okay? So it's undisputed, even by the defendant, that at least by the third incident, right, the employer was notified, they conducted their investigation, and they did what they did. So let's assume, for purpose of argument, that we think that that's reasonable, okay, what they did. There seems to be a dispute of fact as to whether or not she provided notice of the first two incidents, right? And so let's say, again, for the sake of argument, that we send that to the jury, right? What sort of damages, then, would your client be able to claim under that scenario?
Your Honor, I think there would need to be the negligence on behalf of the company in order for her to claim damages. And I think there is very clear negligence.
Let's break it down by incident, okay? So after the third incident, under my hypothetical, the employer takes reasonable steps. I know you disagree with that, but let's just, humor me here. Your client says she notified the employer of the first incident. The employer says no. Your client says she notified the employer of the second incident, and the employer says no. So that presumably would go to the jury, right, as to whether or not the employer was provided notice. And if the employer was provided notice and did nothing, and there's no dispute that the employer didn't do anything before the third time, then presumably there might be some basis for employer liability. But assuming that's the case, what sort of damages would she be able to recover during that interim time, if any? What would your theory of damages be?
I think it would largely be emotional distress damages because she was subjected to having to endure further sexual harassment even though she put the company on notice after the very first time that he rubbed his genitals against her.
So under that scenario, what you're saying is that you would seek damages for emotional injury and pain and suffering from the time she gave notice of the first incident to the company, assuming that the jury finds that, up until the company takes remediation efforts with regard to the third.
Certainly, there's still negligence with regard to the first two in failing to discover the harassment. Your Honor, I see I've cut into my rebuttal time. I'll reserve the remainder of my time for rebuttal.
Okay, thank you, Ms. Barr. Okay, Mr. Tisonis?
Good morning. May it please the court. My name is Gregory Tsonis, and I represent the defendant appellee El Milagro, Inc. The district court conducted a holistic review of the record in this case, considering all the conduct alleged by the plaintiff appellant in its totality. That conduct consists of 3 incidents of brief physical contact by a coworker, 1 verbal statement to plaintiff by a different coworker, and alleged verbal teasing and vulgarities that plaintiff overheard from 4 different coworkers in total. Correctly applying the Supreme Court and this court's precedent and giving plaintiff the benefit of all reasonable inferences, the district court determined that as a matter of law, the collective acts alleged failed to constitute objectively severe or pervasive.
Now, as I understand counsel for the appellant, she in effect challenges you and says there's no case in this court where the conduct was was of this magnitude and we did not find it severe. Can you tell us of a case like this where we did not find it severe?
Thank you for the question, Your Honor. I think, in fact, very recently, last year, in the case of Anderson versus Mott Street, a decision issued by this court, a plaintiff who worked in a restaurant experienced several incidents of physical harassment as well as verbal conduct that she alleged was harassing. In that case, there were 3 to 4 instances of physical harassment, which included one grab of her buttocks, in addition to other inappropriate contact.
Did it include someone rubbing their penis against her buttocks?
No, I believe the conduct.
Isn't there a difference between someone going up to her, a person and rubbing their penis against that person's buttocks versus slapping them or pinching them with their hand, like standing next to them, which I think was what happened in Anderson, right?
I think there would be a difference in that case, Your Honor, but the record in this case.
And you're saying that difference is not material?
I'm saying, Your Honor, that difference is not material in this case because that's not what the record establishes.
But doesn't the plaintiff testify that that's what happened? She says that he came up behind her and rubbed his genitalia against her buttocks, and she turned around and he kind of smiled and said, "Oh, sorry," but in her mind, that his reaction, at least as she testifies, indicated to her that it wasn't accidental and it was intentional because there was lots of room around where he could avoid her. At least that's what she testifies to. And don't we have to, at this point at least, I mean, jury might find, different facts, but on the record before us at summary judgment, we have to assume those facts to be true. And that's why, I was surprised in your brief when you talk about the facts. You say her first occasion describes she first described an occasion in which the co-worker rubbed against her as he passed behind her. It seems odd to characterize the action of someone rubbing their penis against another person's buttocks as someone casually rubbing against her. And so I wonder whether, as you do in your brief, the describing or viewing the facts in that fashion is contrary to the standard that we should apply at summary judgment.
Thank you for the question, Your Honor. I think the record evidence here that plaintiff testified to, specifically at ECF 145-4 at page ID 6, was that Gutierrez approached her from the right, passed behind her, and when she had turned to her left, he had already passed. So that belies this notion that Gutierrez stood behind her, pressed his genitalia, and rubbed them against plaintiff's counsel.
In her report, though, about the incident, she talks about the fact that he rubbed his genitalia against her, right?
That's correct. She uses the word rubbed and qualifies it as an accident, or what she believed at the time to be an accident. But through the second and third incidents occurring,
in her testimony on page 77, she's asked, "Do you think that Francisco intentionally rubbed his genitalia against you?" And she says yes.
That is correct, Your Honor.
But you just told me that in her deposition, she doesn't say that. But here, I have it in bold on page 77. She specifically says that he came up against me and rubbed his genitalia. In other words, he rubbed his penis against me. Why don't we have to take her at her word, at least at this stage? Why should we construe it the way you do, as just kind of an accidental rubbing?
Thank you, Your Honor. I think viewing plaintiff's testimony as a whole is part of drawing the reasonable inferences, both in her favor and what it qualifies as.
Well, but if you think she overstated her testimony at that point, your remedy is to cross-examine her at trial before a jury, right? So the jury can make its own determination as to whether or not that statement can be believed. It's not up to us to draw those credibility determinations and weigh her testimony based upon the record before us, at least at this stage. Is that correct?
That is correct. And the district court also gave plaintiff the inference that the conduct was intentional, but recognized that.
I don't know if the district court did quite that. I think in my mind, the district court also characterized the actions much like you did in your brief. I could find it here, but it seems to me that the district court also kind of characterized it as kind of a brief rubbing as Mr. Gutierrez walked by. That doesn't seem to me as like a faithful compliance with the Rule 56 standards either.
Certainly, I think the court gave her, and expressly, I believe in the opinion, stated that granting the plaintiff the inference that it was intentional, but noting that her basis, and her sole basis on the same page of testimony that you quoted, for alleging that it was intentional was only because he had an alternative way of passing her without making physical contact. But her testimony or subsequent testimony was that she believed the conduct at the time in her contemporaneous written statement to be accidental, and that in terms of duration, that when she had turned, he had already passed. So I think that informs the level of severity of the incident when we are looking at the objective criteria of severe and pervasive conduct sufficient to substantiate a hostile work environment claim. And does
the record have any, does it tell us what the configuration of that production floor looked like? Could he really do his job? Could she do her job and not have that kind of contact?
At the time of the incidents here, this was during the time of COVID, and my understanding is that there were alterations made. There's no photographic evidence in the record that would allow that sort of assessment. The plaintiff has testified there was ample room. I believe Mr. Gutierrez's testimony was just that it was always cramped and crowded given the constant packing of the product at the facility.
Mm-hmm. So the jury would have to evaluate that, I suppose, in determining his credibility.
If it were sufficient to constitute objectively severe pervasive conduct, that may be a jury issue. But if the conduct, either individually or collectively, the 3 physical incidents that she alleges are not sufficiently severe and pervasive under this court's precedent and under what has been assessed in terms of conduct by other cases, which I think this case falls far below what some of the conduct was in some of those other cases.
What would be the basis for employer liability? Let's say the facts are exactly as the plaintiff alleged with respect to the first incident. I'm not aware of any cases that hold, in our court or maybe any others, that hold that a single incident like the one described would be severe and pervasive to affect the workplace environment, to constitute a hostile work environment. I think we'd have to change the law to make that finding. But if we did that, what's the basis for employer liability when the employer subsequently conducts an investigation and finds that she's not credible? Is there any basis for employer liability? I mean, what are they supposed to do? Fire Gutierrez nonetheless?
Thank you, Your Honor. I agree with you. There's no basis for employer liability.
Are there
here.
any cases that suggest that there's no basis for employer liability when the employer? We have cases that say that if an employer takes an action just because further acts of harassment no longer occur does not necessarily immunize the employer, right? You agree with that?
That is correct.
And here they send a letter of reprimand to Gutierrez, and there's no further complaints of any harassment by the plaintiff. Is that right?
That is correct. There's no conduct that she alleges Gutierrez engaged in since the day she made her complaint.
Did the company identify any witnesses that were interviewed during discovery? You're more familiar with the record than I am. Did the company fail to interview any witnesses that allegedly had seen this particular conduct?
No. During the interview, so part of the company's standard process is to get written statements from the individuals, conduct verbal interviews with each of the individuals, which they then sign off on with a member of Human Resources. During that interview and in her written statement, plaintiff did not identify any witnesses to the alleged conduct.
Was the argument made below that the company's investigation was somehow inappropriate or not thorough? Did the plaintiff press that argument below in the district court?
I believe at the district court level, the plaintiff alleged, as they allege here on appeal, that the investigation was inadequate. The discipline issued to Gutierrez was just
But why
discipline.
specifically was the investigation inadequate?
As Your Honor noted earlier in questioning plaintiff's counsel, plaintiffs contend that there's an obligation, there's a duty to seek out witnesses, to try to get more information that the plaintiff herself has not offered in her complaint to the company. We don't think that that is the law, and we similarly have not identified any such precedent. We do have precedent, however, that in terms of employer liability, to the question you asked, there is precedent that establishes that mere conduct that does not satisfy the severe and objective conduct for actionable sexual harassment, notice of conduct that falls below that threshold does not constitute notice of the employer of the subsequent harassment. and that's the Bombaci decision. This is on page 50 in our brief that indicate, knowledge of sexual jokes or inappropriate comments doesn't establish sexual harassment, notice of sexual harassment, because the incidents complained of don't establish an actionable hostile work environment.
Mott was the restaurant case, wasn't it? Where
That's
it was
correct.
the hostess that was continually being grabbed in the butt and comments being made directly to her by coworkers, which she included in her EEO complaint. So those were before us at the time. Is that right? It's fuzzy. I think I remember that case, but I don't remember the details.
That is correct. As I mentioned, it was 3 to 4 incidents of physical contact, including grabbing the buttocks, a coworker, who I believe was the bar manager, calling her a bitch, and a manager telling her she should wear tight, form-fitting clothing.
Okay.
So with respect to employer harassment and employer liability as to harassment, the conduct, the first or second incident prior to plaintiff actually reporting the conduct to Human Resources wouldn't have put the employer on notice for a number of reasons. One is, as I mentioned, the conduct that doesn't satisfy the severe and objective conduct standard for actionable hostile work environments don't establish an employer's knowledge of that. Similarly, though, granting plaintiff the inference that she made the verbal complaints to Brito, her supervisor, the way that she described those complaints in terms of an accident has happened. She subsequently gave some information, and certainly, as Your Honor noted, she did state that she believed the conduct to be intentional. But the way that she qualified, it's undisputed at ECF 145-4 at 86 that she understood that her supervisor took it as an accident, that he understood the first incident to be an accident, and that when she reported the second incident, she testified that she told Brito that a new accident had occurred and described the incident as Gutierrez lowered his hand touching my buttocks on the left. That conduct is insufficient to put the employer on notice and cannot establish, even assuming those reports occurred, a basis for employer liability.
What about her, just again reading from her deposition, what about her testimony on page 84 and 85, where she says she told Brito after the first incident that specifically told him that Mr. Gutierrez rubbed his genitals on my buttocks. And she told him that she felt very bad and felt very uncomfortable as to what happened, and told him that she thought Mr. Gutierrez intentionally did so. What about that testimony?
But certainly, I think, again, she is established in her testimony and granting her the reasonable inference at this stage that occurred, that she reported it as intentional conduct. I think it is also undisputed, though, that she qualified and she understood after that report that her supervisor believed it to be an accident. And I think that is relevant for purposes of the employer liability, that even granting plaintiff the reasonable inference, she reported it in that manner, she described it as intentional, and she described the conduct as we've discussed here today, that her plaintiff believed it to be
So
accidental.
if Brito thought that it was an accident, you're saying he had no obligation to alert HR of this complaint, even though the complainant thought it was intentional? Does he have that authority?
Under the company's reporting policy, a supervisor such as Brito, yes, is required to report that to Human Resources. However, for Title VII purposes, when we are considering, I guess, supervisor liability or the threshold for which a supervisor is, his acts are imputed to the company, he was not, it's undisputed that he doesn't have the authority to hire, fire, demote, or otherwise transfer.
Right, but the company's policies instruct her to tell Brito, right? It says if anyone that experiences harassment should tell their direct supervisor or immediate supervisor. I forget what exactly the language is. And that's what she did. I mean, don't we have case law saying that if that's the procedure the company lays out, then the company's obliged to abide by its own procedures? Because after all, the employees are relying upon those procedures to notify the company of any perceived wrongdoing.
I see I'm out of time. I'll answer your question briefly, Your Honor. The company's reporting policy does say that you may report any acts you consider harassment to a supervisor, Human Resources, or a member of management with whom you feel comfortable. There is precedent, as you note, Your Honor, that states reporting to a supervisor is obviously reporting within the reporting policy, qualifies as a report of alleged harassment. We have identified a couple of cases in our briefing, I believe it's the Yankins case and the Parkins case, that demonstrate that certain supervisors that lack the authority to actually alter the terms and conditions of employment.
So, but you agreed that, I'm sorry, Judge Kush, do you mind if I?
No, go ahead.
You agree that Mr. Brito was Ms. Sanchez's immediate supervisor, right?
That is correct.
And your manual says must report it to their immediate supervisor, and that's what she did. And so she followed your manual, and are you saying that she should have this knowledge of, what different circuits have said about whether or not, which supervisors are real supervisors versus fake supervisors for this purpose of notice?
No, Your Honor, that's not what I'm contending. I think, as we noted in our briefing, she could have, and it was, there's evidence in the record establishing she's aware she could have reported it to Human Resources. I understand she contended in her deposition otherwise that she didn't, but the documentary evidence establishes that she knew she could, and she never reported that conduct to Human Resources as an alternative. That when faced with an action, some of the precedent that we've cited obligates the plaintiff to pursue alternative reporting mechanisms.
Even though your manual tells her she can report it to Brito?
The manual, yes, does say she may report it to her supervisor, but the method by which she described it, even as she believed it to be intentional, again, Brito understood it to be accidental, I think is clear from the record of the plaintiff's own admission.
Thank you.
Thank you, Your Honors.
Thank you, Mr. Tsonis. Ms. Bauer.
Thank you. Your Honors, Mr. Tsonis just recited an entirely different version of the facts from Ms. Sanchez's account, and that's exactly why this case should go before a jury. Appellee presents a watered-down and sanitized version of the record, but Gutierrez did not just brush up against Ms. Sanchez. He intentionally pressed his groin into her buttocks and rubbed his genitals against her, and then groped her buttocks twice after that.
Okay, assume the facts are exactly as you say they are. He rubbed up against her, pressed his genitals against her buttocks. What case supports the position? I'm going to read to you from Patent that the workplace was so permeated with harassment on the basis of sex that the conditions of employment are altered and a hostile or abusive work environment is created based on that one incident. What case supports it?
There's no case that's been heard that's that severe. Somebody rubbing their
Well,
genitals.
wait
at
a
least not
minute.
that
I
I'm
mean,
aware
sticking
of.
your hand under somebody's shirt and grabbing their breast is less severe than walking past someone and rubbing their genitals against their buttocks when she turns and he's gone? Come on, you can't be serious
But that's not
about that.
construing the record in her favor. He intentionally rubbed his genitals against
He's wearing
her.
clothes, and so is she. And you're suggesting that sticking your hand under somebody's clothes and grabbing one of their private parts is less severe than what happened on that one incident?
It wasn't just the one time. He groped her
I
buttocks
know, but I'm
3
asking.
times.
But the third time they conduct an investigation, which is a major problem for you because they respond. You agree with that, right?
Yes, but the employer doesn't get to serve as their own jury and just decide that the plaintiff is not credible. If that were the case, then the employer would
Who
be able
gets
to
to
insulate
decide
himself.
that?
The jury does when the case goes to a jury.
Always. As long as the employee complains, it makes no difference. Why would an employee ever conduct an investigation under your theory? Because all the employee has to do is complain under what you're arguing. The employee complains, they get a jury. It's that simple. That is not the law.
There is the threshold of the severe and pervasive standard first. But all that's needed for negligence is clear notice, and we have that here not once but on 2 occasions.
So it makes no difference so what you're saying is we should write an opinion that says it makes no difference what the employer does. Nothing. The employer should in that case do absolutely nothing because it'll be up to a jury to decide. That's your argument.
No, but here a reasonable jury could find that the employer was negligent because they didn't interview witnesses, despite their conclusion that if it happened, there would have been witnesses. That's
What witness
negligence.
did she identify that was not interviewed?
She was not. The record doesn't reflect that she was asked to, give a witness. But the onus is on the employer. Ms. Sanchez is not in charge of going and interviewing all her other coworkers. That's not a position.
I guess
that
they
she
could
should
have
be.
employed everybody in the plant, but most employers don't do that. I mean, they're in the business of business, right? All right, thank you, Ms. Barr. We'll take the case under advisement. All right, case number 2 is USA Savings Bank versus Goff, appeal number 25-1730. Hold on for a minute, Mr. Schultz. Make sure everyone gets settled here.
Me as well, Your Honor.
Okay, Mr. Schultz, whenever you're ready.
Good morning, and may it please the court. I am Ted Schultz, representing USA Savings Bank, which appeals an August 2023 arbitration decision. Against it, awarding $0 in actual damages, but $10,000 in punitive damages and $77,000 in attorney's fees. This is a case about an arbitrator ignoring the express contractual limitations in the arbitration agreement as to their authority. The arbitration agreement here specifically states that that the arbitrators has a limit on their authority, that the arbitrator if the arbitrator has made a punitive damages award, the arbitrator must conduct a post-award review. That post-award review applies the same standards for the first time in the arbitration as would be applied by the state in the state where...
Mr. Schultz, can I ask you, if we reverse here, what's the remedy?
The remedy is that the arbitration must take place again.
Well, based on what? Based on why wouldn't your client just be entitled to the review of the punitive damages award?
Because the arbitrator has stated that they do not believe that they have the authority to do so.
But what if we said they do? Then wouldn't your client just be entitled to that review? In other words, would the rehearing just be that the arbitrator was required to conduct the post-award review?
The arbitrator...
I know you don't want that, but why would that not be the remedy? Why wouldn't we just send it back for because she already did that, kind of.
Respectfully, I disagree that she has done the post-award review, kind of. I don't believe she's done a post-award review at
Well, she
all.
didn't do it at all, but the point is, you made arguments against punitive damages, and I understand maybe you would make she comes out with the punitive damages award, and if there was a post-award review, you would have filed a new brief, which would have made additional arguments against punitive damages.
That's
right?
correct. Your Honor.
So if we reverse, why wouldn't we just reverse for the arbitrator, this arbitrator or another arbitrator to conduct that post-award review? Why would we start all over again?
I believe that the problem is, Your Honor, that there is no mechanism under the AAA, according to this arbitrator. She has said, I have no power to do so under the AAA rules. If you find that the arbitrator has committed error and that she has applied the wrong rules, as we believe she has because she has not complied with the arbitration agreement, there's no way to re-empower her, to force her to come back. You could ask for a different arbitrator, but if it was a different arbitrator, then under the arbitration agreement, the same arbitrator is supposed to hear the entirety of the arbitration, not that one arbitrator hears one part and another arbitrator hears another part. There's no easy way for this court to assert jurisdiction over the arbitrator and say, you must now do this one other part for us. It's not like the other arbitration cases that are common to this court, where there's an ongoing business relationship, a union and a business. And because of that, there's ongoing arbitrations. This is a one-off arbitration of this dispute. You cannot reopen it and force the matter back. At the most basic level, I do not believe you have the authority to simply order the arbitrator. What if she refused? What would you do then?
Mr. Schultz, this clause that is in dispute here, does your client have this in all of its arbitration agreements?
Yes, it does. At least so far as I know.
Has it ever been litigated before?
This particular issue has never been litigated before. This arbitration clause was added in 2021. I must say I do not know what the prior arbitration clause stated at the top of my head. but I believe that it was very, very similar.
Does the record contain any articulation as to why your client wants this clause in its arbitration agreement?
The record does not, but I believe that it's absolutely clear why we would want it. Having a post-award review gives us a bifurcated process. We would prefer in the arbitration to argue at first the merits beyond and not focus on punitive damages. And then if there's an initial award, we would want to try it again. We would want to try the issue of punitive damages and argue about punitive damages and why they may or they should or should not be awarded. We don't want those two things together. That's the whole purpose of splitting this up, like any other bifurcation.
As I understand your opponent, their view is that, well, the damages are all going to be mentioned during the merits inquiry in any event. Clearly, the district court, the arbitrator took into consideration punitive damage because she awarded them with the initial award. So that there was really this whole thing is rather pointless.
Respectfully, I disagree, Your Honor. I don't think it's pointless at all. If the first part of the arbitration deals specifically with the merits, and the second part is dealing with the specific issue of punitive damages, and very appropriately, the punitive damages award is subject to a different choice of law. The initial damages award and the initial hearing is held under a standard where anything under the FAA, that means any federal or state opinion, would be relevant. But here, at the punitive damages level, it's a different analysis.
Is that, Mr. Schultz, if I could ask you about that. The credit card agreement says that the governing law is Nevada, right?
That is correct.
And so the arbitration addendum says the arbitration addendum is part of the credit card agreement.
That is also correct.
Right? And so so how do you square the choice of law in the credit card agreement with your argument now that the addendum, which is part of the credit card agreement, is now governed by some other choice of law provision?
Certainly. The arbitration addendum specifically says what laws the arbitrator must use in rendering their decision. And since the
does that then that trumps the specific language in the agreement itself that says the agreement's governed by Nevada law?
But the overall agreement being governed by Nevada law doesn't obviate the specific points of this dispute will be governed by the place of where the arbitration is or by general FAA rules.
And along those lines, looking at paragraph 8.13 in your agreement, it says with regard to this post-award review, before the decision becomes final, the arbitrator must also conduct a post-award review. As I understand the record here the arbitrator issued an interim award.
That is correct.
And then later did a final award. Between the interim award and the final award, did your client request the arbitrator to review the punitive damages award?
No, Your Honor, we did not. We followed what the arbitrator said. The arbitrator said, here's our initial award.
Did you tell the arbitrator, well, actually under 1.13, it says before the decision becomes final, we're entitled to a review of punitive damages. Did you raise that before the arbitrator?
No, because we didn't know that a final award was coming until the final award was entered.
Didn't she ask, but she issued, I guess I don't understand. Maybe I'm not clear on the timing of things. I thought there was an interim award. She requested additional briefing on attorney's fees. She issued a final award, and it was after that that you asked for a review of the punitive damages award.
That is exactly correct. And what I mean by we didn't know that it was coming is we had no way of knowing that the final award was going to be issued without her conducting this post-award review that was supposed to occur before that final award was issued. There's no way we would know.
Well, did you bring it to the arbitrator's attention?
It's self-executing, Your Honor. No, we did not, because we expected that that was going to occur. That's what the arbitration agreement calls for. We wouldn't think that we have to remind the arbitrator that she needs to follow the arbitration agreement, because that's specifically the source of all of her power.
Well, I guess, if I were the arbitrator, I would look at this and say, okay, well, before decision becomes final, they have an opportunity to ask for a post-award review of the punitive damages. They haven't, so I guess I'm going to release my final award.
Respectfully, though, the language says that she must conduct the post-award review. It doesn't say that we have to ask for a post-award review. And we certainly didn't know that she was going to suddenly issue the order. As a matter of fact, what I suspected was going to happen when we filed our motion to reconsider that final order was very simple, was that she would say, oh, you're right, I should have conducted this. I will conduct the review now. That couldn't have been the final order. But instead what she said was, no, under the AAA rules, I can't issue a post-award review. I won't do so. At that point, we have lost the ability to have this.
Okay, and you say that that's not her interpreting the agreement, saying that the AAA rules trump the arguments that you're making, but that despite the fact that you brought this provision to her attention, she merely just completely ignored it.
She ignored it, yes. There's a big difference in your case law between ignoring an arbitration agreement and interpreting it, and this one clearly falls on the line of ignoring.
What if she had added a sentence in the award saying, you know what, they make this argument, I don't agree with it because I don't think the contract calls for that? Would that be ignoring or would that be interpreting?
Under U.S. soccer, I believe that would fall within the making noise of interpretation exception, but would not be a true interpretation. But if I may, if she had said, I have performed the review and I find under the Seventh Circuit that these punitive damages are fine.
Oh, no. What if she says, you know what, I read the 1.13 and I've read the AAA rules, and so I think that the AAA rules, I disagree with the position that, and I believe the AAA rules trump, and so I'm not going to go back and conduct this assessment. I mean, she's wrong, but...
But not only is she wrong, Your Honor, if she were to do that, I believe that what she would have accomplished is she would not be interpreting. She would simply be ignoring. She would be, as happened in Tootsie Roll, she would simply be saying, no, I'm going to apply this rule. I don't care what the arbitration agreement says. And that would be a violation. Your Honor, I note that I am cutting into my time. May I reserve?
Sure.
Thank you kindly.
Okay, Mr. Dower.
Good morning, Your Honors. May it please the Court. My name is Alexander Dar. I'm here for the appellee, Michael Goff. I'd like to begin with the line of questioning that you were exploring there, Judge Lee, as pertains to the sort of timeline and the interim award. And I'm at page 26 of the short appendix here. And I'll note that in the interim award, and that interim award issued on July 7th, 2023, the arbitrator called for a briefing as to fees and costs and said, upon and after such submissions, the matter shall be deemed submitted to the arbitrator for determination in a final award. It was very clear to the parties what the only remaining issue was in the arbitrator's eyes, and that was the issue of fees and costs, which had been explicitly bifurcated for sort of obvious reasons. No sense in briefing fees and costs if plaintiff or claimant doesn't prevail. And so this suggestion that USAA was somehow caught off guard, I just don't think the record supports that interpretation.
Are you suggesting then that was the post-award review?
I don't think that it voids the post-award review. I think
No, I said that it was. Was there a post-award review or was there not?
I would submit that there was a post-award review here, Your Honor. And
when did that occur?
I believe it would have occurred in between the interim award and the entry of the final award. And that post-award review wasn't necessarily explicit, but was a reaffirmation of the interim award. And then I think there was a subsequent additional post-award review when USAA made all of its arguments in its request for review on September 14th, and there was a denial that the arbitrator did word its ruling as a denial, but the arbitrator explicitly reaffirmed, that's the word that's used in that denial, I reaffirm the awards. And that was the ruling on September 19th. And I'll note that there is that passage of time. So it's not as though this was a knee-jerk, the arbitrator looked at it and said, no, I'm not going to do anything. The arbitrator received that request, had it for 5 days, and then issued its short reasoned decision as pertains to the requested review. And then as for the review itself, I'd like to note that I think a portion of this provision in the arbitration provision that is sort of being glossed over here by USAA, and that is that there is an entitlement to a post-award review of punitive damages, allowing the parties the same procedural rights that would be permitted in state court where the arbitration was held. I'm not familiar with a procedural right to a post-punitive damages award review that exists in the state courts of Illinois. And so I would submit that what USA is asking for here actually doesn't even exist. I understand what they were perhaps expecting, that we would have a separate round of briefing as pertains to the propriety of the punitive damages award, but I'm not aware of any procedural right that exists that encompasses such a mechanism in the state courts of Illinois. And so I would submit that there wasn't, to the extent there wasn't a post-punitive damages award review, that's entirely consistent with the arbitration provision, and that's where I actually disagree with the district court's finding that something did not happen that should have happened. And I've asked repeatedly throughout the briefing and brought this up several times, for USA to point to this procedural right that they would enjoy under Illinois law that they contend they were denied. And I haven't seen that, and I would submit that it doesn't exist under Illinois state law.
Do you agree with Mr. Schultz regarding the remedy if we were to reverse?
I don't agree, Your Honor. I believe that, and we're going a little bit out of the briefs, and I know the circuit rules on quoting or citing to materials that's not in the briefing, so I hope you'll indulge me on it. But under the consumer rules of the American Arbitration Association, an arbitration can proceed consistent with an order from a court. And so I would submit that if you were to reverse, the remedy would be to reverse to the district court for an order to issue from the district court to conduct this additional punitive damages review. And the AAA would be, that would be well within AAA's grant of authority under, I believe it's Rule 1 of the AAA consumer rules.
I think some circuits say even that the district court can conduct the review.
That's right, Your Honor, and I would submit that at this point now where we are more than 2 years after a final award, that anything that we could do to shorten this procedure would be most consistent with this arbitration provision that the appellant includes in its contract of adhesion that brings us here today. If the panel doesn't have any other questions as to the substance of the appeal itself, I would like to speak very briefly to my request for sanctions. This case comes before the court on an underlying Equal Credit Opportunity Act claim. That's a claim that has a fee-shifting provision. Obviously, we have fees that are at issue. I cited at length in my motion the supporting case law from this court that I believe supports sanctions. I would simply note that if there is not an award of sanctions in a case like this, then what we've established is a sort of framework whereby a large institution can circumvent or at least dramatically dilute the remedies available to consumers under these federal statutes.
Mr. Dar, this is an odd set of facts. Your client has no damages, received $10,000 in punitive damages and $77,000 in attorney's fees, and you're asking for sanctions. That's a bold request.
I am, Your Honor, but
it's a very bold request.
Well, I understand, Your Honor, and it is unfortunately, or maybe unfortunately is the wrong word to use there. It is oftentimes the reality when it comes to these type of
I mean,
fee shifting
we don't often
statutes.
issue sanctions even in near frivolous appeals.
I understand, Your
I
Honor,
don't think
and
this is anywhere close to frivolous.
I would submit, though, that what the court is hearing are arguments that have been raised to the district court, rejected by the district court, and simply being
That
repeated
happens
again.
all the time. Were you here for case number 1?
Well, I was, Your Honor, I was. But I would submit that there is, and we've cited this in our brief, so I won't belabor the point, but that there is substantial case law, specifically when we're talking about the arbitration context, where sanctions are more merited, shall we say, from this court, specifically because, as is playing out here, what's been denied is the speed and efficiency of the arbitration process. And I do believe that the request for sanctions is merited. Hearing no other questions, I'll rest on our briefs.
Okay, thank you, Mr. Dar.
Thank you.
Mr. Schultz, anything else?
Very briefly, Your Honor.
A few items. Looking at SA 26 from the short appendix, it says, upon after such submission, this matter shall be deemed submitted to the arbitrator for determination of the final award. There's nothing in there that says the matter is closed. I'm not going to have any more hearings. The determination of the final award is what we're expecting. To suggest that this is the written decision that is required on the post-award review, that doesn't make sense. And everything after, every written document after submitted by the arbitrator doesn't conduct a written, reasoned explanation of her decision. There's nothing in there that says, I have looked at this and I am issuing the opinion because. Instead, all there is a simple statement of, no, that's my final judgment. That being the case, she has not complied with the specific requirements of the arbitration agreement. If the arbitration agreement is supposed to matter, and it's supposed to matter because it is the source of all of her power, then she has to comply with it. Under 9 USC 10A4, if she's exceeding her authority, which is exactly what she's doing here, then in fact, the court must vacate. With regard to sending the matter back to arbitration, I am much less sanguine about the arbitrator agreeing to perform this and what the court will do if the arbitrator simply does not perform it. In other words, how will we know that the arbitrator will do this? What we're supposed to have is an arbitration agreement where we have a bifurcated process. We didn't get that. And trying to build it now in with an arbitrator who may or may not be willing seems like a very, very difficult task to me.
Mr. Schultz, do you have a response to Mr. Dar's argument that on its face, 1.13 does not provide you with the type of post-final award review that you are seeking here?
Yes, it's in my response brief, and I deal with it. The language of the arbitration agreement very specifically says that we're supposed to have all the same procedural protections as would exist in a state proceeding in the state of arbitration. What I've done is I've cited a number of cases, both federal and state, all of which have post-hearing rules. In other words, what you are able to do is file briefs, at the very least, a motion to reconsider in federal court under Rule 59. And we would be entitled to the same protections as would be in that.
Thank you.
With
Okay.
that, I thank you for your time.
Thank you, Mr. Schultz. Case will be taken under advisement. And we'll move to our third case, Passwater versus Pretorius, appeal number 25-1149. Mr. Burkhart, whenever you're ready.
May it please the court, Dr. Ripito diagnosed Brad, a paranoid schizophrenic, with a clear and imminent risk of substantial suicide and self-harm, ordered emergency psychotropic medication, and then abandoned his medical judgment. As a result, the very risk of harm he diagnosed occurred, and Brad ripped out his testicles, gouged out his eyes, causing permanent blindness. Brad designated sufficient evidence of deliberate indifference to convince a reasonable jury to survive summary judgment. If you look at the evidence Brad designated, one is the admission by Dr. Ripito that he undertook no post-medication assessment. Dr. Ripito's deposition testimony confirmed the standard of care to review post-medication assessment to determine whether the medication is helpful and that the behavior is improving.
So as I understand it, Dr. Ripito was providing professional services remotely. He was located in Florida, is that correct?
Yes, Your Honor.
And the typical procedure, as I understand it at least, is that he then would rely upon the nurses and the professionals at the facility to do any necessary follow-up and to alert him if anything, rises to a level of consequence. And it seemed, didn't he do that here?
No, there's no evidence in the record to indicate he undertook any assessment, any communication.
No, but that he relied on the staff at the facility to do the follow-up as he usually does.
No, he designated no evidence to that fact, but the point is, that's one source of information is a nurse communicating information. Another source could be the mental health professional communicating information. He had access to the EMR, electronic medical records, which showed Mr. Links going in roughly an hour and a half after the medication, show his psychosis had worsened. And so he had the opportunity and he had the duty. He's a medical provider. He's the only one who can issue new orders for medication to stave off the imminent risk of suicide. So yes, he can certainly rely upon them, but in this case, there's no evidence he did because there's no evidence that any of the nurses undertook any action subsequent to the administration of that medication.
How does that make him, though, deliberately indifferent if he was never notified of any problem?
Because he was the one that diagnosed Brad of an imminent risk of self-harm. He's the one who
But what was he supposed to do? I understand facts are horrible in this case, but what was he supposed to do? Fly up here and sit outside his cell?
He was in Florida. He was able to make that under the IDOC policy. He had to meet these requirements before ordering the emergency medication. He did that review and made that determination based upon whatever information he had at that time. After ordering the medication, he just doesn't get to go out and play golf with his buddies and just hope that somebody takes care of Brad, somebody can diagnose him.
I think that's what my doctors do.
Well,
I don't know what was he supposed to do.
what he does is he can look in the EMR and he can see Mr. Links went down there an hour and a half later. His psychosis is worsening. The medication's not working. He has the opportunity to communicate with the nurse. The policy even required the nurse to get back to him.
You're imposing an affirmative obligation on the physician to initiate the contact after the medication had been administered, am I right? An affirmative obligation. He cannot rely on the fact that the caregivers on site will contact him if he's needed.
He has the right to rely upon other people, but he has to ensure that that's actually done. He's the medical provider who has the affirmative duty to ensure that that patient is not going to take
So after prescribing what I think everyone agrees was a proper medication regimen for the patient, and working remotely under a protocol where he knows there are medical people on site, although not physicians, he's still deliberately indifferent if he doesn't initiate the inquiry. Is that your position?
Position is, yes, he has the affirmative duty once he administers emergency psychotropic medicine because of an imminent risk of self-harm to follow up to see, as he testified himself, the standard of care requires to assess whether the medication is helpful or not. Look at it this way.
What if he ordered a knee brace for a torn ACL? Would he have an affirmative obligation to ensure that the inmate wore it?
No,
What's the difference?
The difference is simply as we indicated in our briefing. This isn't a case where you're giving somebody antibiotics because they have strep throat and says, all right, maybe come back in 2 weeks.
I mean, what's the standard? How would we write an opinion that says is it just limited to mental health medication? Is it how do we say the doctor in this case is deliberately indifferent if he doesn't follow up with the patient to ensure that the medication is working, but in another case, if he prescribes some pain medication for a toothache, he's not deliberately indifferent?
Because this case involves the objective medical need of suicide, an imminent risk of suicide that he diagnosed. And so, yes, he has that duty to follow up because the courts look at the totality of care. To your point, Judge, no one's disputing the care leading up to the administration of the medication was appropriate. No one's disputing after the self-harm and he was removed from the cell and taken to the hospital that care was appropriate. But we're looking at totality, and the totality is from the time after he administered the medication to the time of the self-harm, there was a complete absence of professional judgment. Standard of care, obviously the standard of care may be different with the constitutional floor, but here we think they're the same because both Dr. Ripito himself and Brad's independent expert testified the duty exists once you administer, in this context, emergency psychotropic medication because of an imminent risk of self-harm. You've got to follow up to see if it's helpful or not, because we know if it's not helpful, the worst thing is going to happen. This guy can suffer self-harm like he did, or worse, suicide. And that's what makes this case different than your knee brace for a torn ACL.
Can I ask? Oh, I'm sorry. Go ahead.
You know, you talk about kind of what he should have done in standard of care, but obviously we all know that the governing standard to establish a constitutional violation is much more rigorous, right? The plaintiff would have to show that no minimally competent professional would have acted in the way that Dr. Ripito did. The medical expert that plaintiff presented before district court does not opine on that standard. It just says that what Dr. Ripito did not meet best practices. I guess my question is, do you have any authority to support your proposition that what Dr. Ripito did is something that no minimally competent professional would do?
I think that goes to the deliberate indifference issue. A jury gets to decide that. We're on summary judgment. The facts and inferences
Well, I mean,
in his favor.
the jury gets to decide that, assuming that a reasonable jury could find that Dr. Ripito's actions didn't meet that standard. And I guess my question is, can you point to anything in the record from which a reasonable jury would be able to find that Dr. Ripito did not meet that standard that's way lower than professional negligence?
Yes, Dr. Ripito's own testimony where he said the standard of care after you administer that medication is to follow up to see if the medication is helpful and it's improving.
But again, we're talking about the standard of care, and the standard of care is here for a negligence claim, but the standard for constitutional violation is like down here. And so I'm asking you if there's anything in the record from which a jury could find that Dr. Ripito's actions, weren't up necessarily up here, but actually were lower than down here.
Yeah, I think what we've designated. I think his admission that he did nothing, the admission that he could have reviewed the EMR to see the condition was worsening, he didn't. His own testimony. I mean, what we're looking at here is, did you know of a substantial risk of suicide? Yes. Were you intentionally indifferent to that? Absolutely. What did he do? He doesn't designate anything that he did post administration. So we're thinking that.
I'm sorry. Could we talk about Deputy Warden Pretorius?
Yes.
For a bit? So you bring up this kind of 2-hour shift, right? And when I look at that report of this horrible incident that happened, Mr. Passwater, the shift that Mr. Fox, I think, was there,
Correct.
the custodian, his shift started at noon. At 1:46, Mr. Passwater starts gouging at his eyes. At 1:56, the video shows that he started grabbing at his crotch area and that blood can be seen at that time. If Mr. Fox had been complying with even the 2-hour shift standard, wouldn't he have noticed those things? And so isn't it really Mr. Fox's refusal and inability to kind of follow the procedures to correctly observe Mr. Passwater that brings upon this horrible injury as opposed to the 2-hour shift? Because it seems like the actions and even the bleeding started within that first 2-hour period.
Yeah, I think what you're asking about is there's some intervening cause that maybe breaks causation. And
I think
would
that's
say,
a much more artful way of putting it than me. Thank you.
But I would say this. First of all, neither defendant has made that argument. And this court has made clear it won't make arguments for a party didn't make for itself. Secondly, neither one has asserted some kind of non-party defense saying, well, you're actually the one responsible, not me. I think thirdly, the injury was foreseeable. If the entire policy was aimed at inmate safety, and the basis of it was for 4 hours, when you've got to stand up and look through this small glass window in the door, you become complacent. So the very risk, the very harm that policy was meant to protect, that occurred. And so,
But the policy wasn't meant to protect attention within that 2 hours, right? That's the whole point of the 2 hours. And so and Mr. Fox, as I understand it, just, he'd be sitting down, some custodial officers would come by, see him standing down, tell him to get up. He would get up for a little bit, but then he would sit back down, even within the 2 hours. And so, let's say, for purposes, of argument, that Mr. Passwater started, really harming himself at the 1 hour stage, and Mr. Fox was just not paying attention. He was sitting down. Would you still argue that it was the failure to comply, a systematic failure to comply with the 2 hour policy that caused the injury?
yes, because I think the whole purpose of the policy is recognized in the email chain was that these people who have to stand for 4 hours become complacent. So they may be sitting down at some point in time. So if you're there for a 2 hour period, you have a better chance of being attentive, and then you have shift changes during that period of time, right when part of the harm occurred. And so yes, I think that it would still show that it was a but-for and proximate cause, the failure to enforce this policy.
Mr. Burkhardt, perhaps you could refresh our recollections. Does Indiana state law provide any recourse for your client in terms of monetary damages?
There's nothing in the record to indicate that, Your Honor.
But it's a matter of law. Can you, as an attorney in Indiana, do you have an Indiana remedy for this kind of thing?
I do not know the answer to that question.
Okay, well, we'll.
And back to your comment, Judge Ali, in terms of intervening cause, causation is an issue generally for the jury. So that, again, these designated facts and inferences, which we believe suffice to allow a reasonable jury to rule in his favor and to address causation.
I think generally you're right. I guess, your theory in this case to bring Deputy Warden Pretorius, though, into the fold is that she was aware that people weren't following this 2 hour policy, that inmate custodians were being allowed to observe people in these kind of precarious situations or suicidal ideation more than 2 hours. And so therefore she was did a little bit indifferent to that fact that people weren't abiding within the 2 hours. and that's what kind of caused the injury. And I guess I see that theory as being a little bit problematic because of the timing that took place in this case. That was just my point.
Okay, I see my time is up, so.
Okay, thank you, Mr. Burkhardt. Okay, Ms. Johnson.
Good morning, Your Honors. May it please the court, Rachel Johnson on behalf of Dr. Ripito. The district court was correct in this matter in concluding that no reasonable jury would find that Dr. Ripito acted with deliberate indifference in this matter, given that he had every reason to believe that the medical staff who were physically present at the Plainfield Correctional Facility on April 16th would abide by the policies in place at the facility. To establish the Eighth Amendment deliberate indifference in this case, a plaintiff must prove the two elements. First, that the harm to the plaintiff was objectively serious, and the second, that an official was deliberately indifferent to the plaintiff's health or the safety. We don't have any dispute about the first prong of the case, that the plaintiff had an objectively serious condition, as was in the record already. However, there's insufficient evidence in the record to support the second prong of the test, that being that an official was deliberately indifferent to Mr. Passwater's health or safety.
Is there anything in the record that would inform us as to what Dr. Ripito's kind of usual practice was in situations like this? Does he check in with the nurses after he prescribes medication like this to a patient? Does he expect them to check in with him after a certain period of time? I mean, is there kind of a usual practice with him and the nurse staff as to kind of reporting back and forth on patients?
I don't know that there's much by way in the record. During his deposition, he testified that he stays in good communication with the staff and that providing orders for involuntary psychotropic medication does happen. You know, there is testimony that he has been familiar with Mr. Passwater. He's been an active treater for Mr. Passwater for several months, so he was familiar with Mr. Passwater. Mr. Passwater has actually had this type of medication prescribed to him in the past. Other than prescribing and staying in touch with the nursing staff on a regular basis, he's had a contract with Plainfield Correctional for a number of years prior to this incident on April the 16th.
I guess what I'm getting at is that there isn't a standard practice that's like the nurses are supposed to check in with them every hour about a patient that receives a particular type of drug.
Not that I'm aware of in the record. However, there is a policy in place for how often the nursing staff are supposed to monitor these patients at the facility after the medication is administered.
And did that take place? Did the nurses here follow that procedure with regard to Mr. Passwater?
That was Dr. Ripito's understanding. Again, he had no reason to believe
I
that
understand
was not
that was
being...
his understanding, but I'm wondering whether the record establishes whether the nurses did in fact comply with the policy with regard to Mr. Passwater.
That is not, my understanding is that yes, the nursing staff was monitoring Mr. Passwater once the medication was administered. Dr. Ripito's action on 4/16 were appropriate in response to Mr. Passwater's condition, but again, Dr. Ripito not being on site, there was only so much that he could do. In response to Judge Kurtz's question earlier, what more could Dr. Ripito do? He was not on site, but he was, as he testified during his deposition, staying in proper communication with the nursing staff. Mr. Passwater was on suicide watch. There was a suicide companion placed directly outside of his cell. Correctional officers were performing runs in the cell house. He was under direct supervision in the placement in the cell house. And Dr. Ripito had every reasonable expectation that Mr. Passwater would be appropriately monitored after the order for the involuntary Haldol medications. For Mr. Passwater to allege that there's no evidence in the record that he would follow up or have any appropriate communication or monitoring of Mr. Passwater, that's simply untrue and is not supported by the record. Dr. Ripito was appropriate in relying on the safeguards in place at the facility. Again, Passwater was located in a camera cell with the suicide watch companion in place. The IDOC policies are in place regarding the monitoring of the patients in the suicide watch placement, so they could be followed by the staff at the facility, the mental health staff, the nursing staff, to make sure that appropriate placements and safeguards were in place for them due to Dr. Ripeto's placement not only outside of the facility, but he was outside of the state. This was known to all in place, making sure that Dr. Ripeto was informed as he needed to be. He had no reason to believe that these things were not happening. And again, if nobody's letting him know, he only knows what he knows. That is what he testified to at his deposition. Plaintiff's argument of the plain reading of the argument of the IDOC policies makes it known that the policies that were in place were appropriate for not only Mr. Passwater, but Dr. Ripeto had no reason to be concerned about the communication with the facility, as he testified that nursing staff was keeping him informed about Passwater's condition on the 16th. And a reading of the plaintiff's experts' report, Dr. Lampkins and Dr. Berger, as we've already established, the dosages were appropriate for Mr. Passwater. Dr. Lampkins in particular testified that it was unclear if the guidelines that were in place for monitoring to ensure that the adequate de-escalation following the medication administration were followed. That was not relating to Dr. Ripeto. That was relating to the nursing staff and the custody staff. And again, Dr. Lampkins, who is plaintiff's expert, he was not making this decision or even kind of this questioning about the nursing staff and custody staff not coming to this conclusion saying that they did, but it certainly wasn't about did Dr. Ripeto do it or not do it.
Does any professional organization set national standards for psychiatric care for people who are incarcerated? Do you know?
In terms of, is there any organization that sets the psychiatric care? Not to my knowledge, but not that I saw, at least in the record that was presented during this case and my review of the case.
Is it common for Indiana to engage a psychiatrist about 800 miles away to care for its prisoner population?
Is it common? In my experience, I don't know, but it's certainly, it happened here. And again, Dr. Ripeto testified that he had been in place through his employment with the Indiana Minority Health Coalition, had been for a number of years, and had been working with the patient population at Plainfield Correctional, had a working relationship with the staff there. I want to be cognizant of my time for Mr. Hunter, but we would ask that the court should affirm the district court's granting of summary judgment as to Dr. Ripeto. Thank you so much, Your Honors.
Thank you.
Okay, thank you, Ms. Johnson. Mr. Hunter.
May it please the court, Kyle Hunter for the state defendant. This court should affirm the district court for either of two reasons.
Mr. Hunter, can I ask you a question regarding the litigation below? What is the constitutional violation with respect to the deputy warden?
It seems to be that the alleged violation here is that a 2-hour policy instead of a 4-hour policy was used for suicide watch companions. And there's no constitutional right to a specific policy, especially one less than 4 hours. And here,
I mean, it seems like that's the argument, right? Like the plaintiff has a constitutional right to a 2-hour watch window instead of a 4-hour watch window.
yeah, that seems to be the argument to me as well. And I think Judge Lee keyed in on the question of observation, and there's nothing in any of the designated evidence that suggests that Deputy Warden Pretorius was on notice that there was any problem with the observation in the 4-hour window, and even
I mean, that's assuming there's a constitutional violation.
that's assuming there's a constitutional violation. And here, absolutely, there's no violation, but also there's no established, clearly established constitutional right to a 4-hour, to anything less than a 4-hour suicide watch companion.
And here, as Judge Lee pointed out, even if she would have enforced the purportedly constitutional 2-hour policy,
that is correct.
Had the same injury. It
started before. And I do also want to point out that there were other redundancies as well. The facts indicate there were other redundancies for observation. The control room has video surveillance of the cells. There are 6 cells in Plainfield. and there's an officer designated to watch that way. The staff is supposed to check in on the suicide watch companions every 30 minutes. And certainly in this instance, what happened on the 16th was terrible. But Deputy Warden Pretorius had no personal involvement, and her and the warden are the only named defendants from the state in this case.
So you said that there's an officer that's supposed to be watching the videos. Do you know why the person didn't, or maybe that's how they discovered it?
In the record, it indicates that they were doing paperwork and not observing. But again, there's no indication that Deputy Warden Pretorius knew of any problem with observation. And actually, if you go back to the emails, it indicates that subordinate staff said in the email specifically, Ms. Sineriz indicated that she would, quote, ensure that they were watched either with an open or closed door. So Deputy Warden Pretorius' subordinate indicated that they would make sure observation, even if it was a 2 or a 4 hour policy. So there's no clearly established right, and there's no constitutional violation. And in addition, there are these redundancies that protect against the question of observation, which Judge Lee identified.
You know, when I read about the custodian, the inmate custodian program, I hadn't really come across anything like that before. What is the program designed to address kind of a lack in staffing, or is it designed to provide kind of another kind of layer of protection? Do you know what the genesis of it is?
I don't know the genesis of it, but according to the policy, it is one of these redundancies meant to ensure that people that are on suicide watch have observation. And again, Deputy Warden Pretorius had no knowledge that there was a problem with observation, only this difference, which is not a constitutional right, of the 2 to 4 hours.
And do you know whether there were had the facility had prior problems with Mr. Fox in his fulfilling his duties as a custodian?
There's no indication in the record of that, or that Deputy Warden Pretorius knew anything about that. If there are no further questions, the state asks that you affirm the district.
Thank you, Mr. Hunter. Mr. Burkhart, we'll give you 2 minutes for rebuttal.
As to Dr. Ripideau, the Eighth Amendment requires adequate medical care. He designated no evidence, no affidavit of him, a nurse, of any care after the administration of the medication. The EMRs show no medical care after that. So we think clearly there was a known risk, and he intentionally disregarded that. As to the issue on the clearly erroneous, or the clearly established right, we don't go down to that granular level of 2 hours versus 4 hours. What we have here is a known systematic lapse in policy.
Is that the constitutional violation, a known systematic lapse in policy?
The courts have said that's...
Which court? Which case?
Well, the Sin case, this court in Sin and in Steigel both recognized that a prison official can be liable for a constitutional violation if they're aware of a systematic lapse in enforcement of a policy.
Critical to ensuring inmate safety.
Yet failed to enforce it.
Right, but that critical to ensuring inmate safety is really important, because here the argument is that the 2 hour policy is sufficient, but the 4 hour policy is not. And so that 2 hour window is critical to enforcing inmate safety.
And that's exactly what the emails show, the reason for that 2 hour policy from Mr. Links, who trained these people who knew about it and said, we have complacency for 4 hours and you're standing in this small window. So we make it 2 hours to ensure the safety of the people who are on constant suicide watch with the door closed. That's a very narrow subset, and that's the critical safety net that they provide.
And the email the March 13th email, the March 13th, 2000 email from Links to the addressees, including Deputy Warden Pretorius. That starts, Ms. Senerez, again, I'll defer to Deputy Wardens to weigh in on continuing the 24-hour watch on your staff issues. But as I read the email, Mr. Links was telling Ms. Senarez, look, the 2-hour policy is in place as of now, and this is what you should abide by. And that's in March 13th, 2024, before this incident. Shouldn't that have given Deputy Warden Pretorius comfort or assurance knowing that the 2-hour watch is going to now be followed by Ms. Senarez because she was told that that's the policy? I don't see how it seems like to the extent that there was kind of a deviation from that policy, in the March 13th email, Mr. Links made it clear to everyone, look, the 2 hours is the 2 hours. And so I have a hard time understanding how that email chain would give Deputy Warden Pretorius knowledge that even afterwards there would be a failure to comply with the 2-hour policy.
Because within those emails, it also says, I went down and spoke with custody staff and mental health staff and couldn't find anyone who was aware of it. So that is communicated to the deputy warden, who knows we've got a systematic problem. And then they have that suicide prevention meeting in March, where that's the whole purpose of that suicide prevention committee, is to handle things like this. And so that she had knowledge of that. And you look at the minutes, it was never raised. There was nothing to say, go out and tell this staff, here's the 2-hour policy, here's how it's implemented. She knew about it and did nothing. Everyone wants to pass the buck. And that's what this resulted in, a lack of enforcement, and the court should reverse. Thank you.
Okay, thank you, Mr. Burkhart. The court will stand in 5-minute recess. Okay, our next case is Majani, I don't know how to say that, versus Voodoo. Appeal number 24-3175. Mr. Flood, whenever you're ready.
Good morning, Your Honors.
Mr. Flood, what happened here? I mean, it looks to me like maybe the district court just got this standard reversed.
That is our position, Your Honor. In effect, the district court's rejection of Deputy Wojda's.
You raised the defense. The district judge found that the plaintiff failed to meet the defense, but nonetheless denied qualified immunity.
That's correct. And in the district court's reasoning, it was because the court felt that it would be unfair to recognize immunity at this stage in the proceedings because it found that Deputy Wojda did not show that his conduct did not violate a clearly established.
That's not, is there any law that supports that application of the standard?
No, Your Honor.
Mr. Wojda, I agree that the standard, as you have kind of articulated writ large, but from the record, Officer Wojda did not make that particular argument at district court, right? And so, in other words, as I went and reviewed the summary judgment motions on this issue, and Mr. Wojda did not say that, the theory against me is a failure to intervene versus and that claim is different than the claim against Mr. Doe. And, focusing on my claim, I'm entitled to qualified immunity because it's not clearly established that I had to intervene in this instance, right? I mean, that's the theory you offer now, but that argument was never made to district court. Isn't that correct?
I would disagree with that, Your Honor.
Can you point to me where in your brief before the district court you made that distinction between, or you meaning Mr. Wojda made that distinction between himself and Mr. Doe?
Well, first I'd just like to clarify that I think the argument was made, but it wasn't developed to any high level of
Well,
detail.
I mean, was the term failure to intervene even mentioned in the briefs? Because I did not see it in the briefs.
I don't recall if the term was used, but I do know.
And so I'm just trying to understand. So I'm trying to figure out what the district court was supposed to do. So let's say the district court, right, had said, you know what, I'm going to deny the motion for the request for qualified immunity at this time because Mr. Wojda never raised the argument before me, okay? And under the principle of party presentation, the district court doesn't have to go off and look at its own theories, right? And so the district court said both sides kind of lumped Doe and Wojda together, right? And Wojda never argued about whether or not the law was clearly established with regard to his duty to intervene. And so since he didn't raise it, I think he kind of waived it. And so I might allow him to raise it again later, but I'm not going to rule on that basis now. That seems like a perfectly logical or reasonable exercise of the court's discretion, given the fact that the argument wasn't even made. So how is that wrong?
Well, the argument was raised in both the moving brief on the motion.
So the argument was raised that there's no clearly established law establishing that Mr. Wojda had to intervene.
Again, I can't recall if those exact words, failure to intervene, were used.
And
but
so,
the argument was made that the alleged conduct of Deputy Wojda did not violate any clearly established laws.
Suppose the district judge had just said, I've got your motion. I'm not going to rule on it now. I'm going to take it under advisement. Let's go on. Could she have just sat on that motion?
I suppose she could have. I
Sure.
don't think there's anything that requires a court to decide a
when
motion.
Said what she did was she denied it without prejudice, and so let's go on. She wasn't going to stick her neck out on a motion that had been badly presented to her. I mean, isn't that basically what would occur?
I mean, she did decide the motion. It wasn't like she put the decision off and said, oh.
Has the plaintiff argued that she didn't decide the motion?
I don't believe so.
I
no.
don't either.
No, and so, I mean, the issue here is that the district court
Did the district court ever indicate that there was factual development that needed to be,
No,
that was
and-
required for her to decide the motion?
No, and
I mean, I'm totally confused here. I thought what happened here is the district judge said the issue of qualified immunity was raised. The plaintiff did not meet their burden, but yet qualified immunity is denied. That's the way I read her order. Is there another way to read it?
No, Your Honor, I don't believe there's any other interpretation of that order. The court was pretty clear in acknowledging that the defense was raised. The burden was on the plaintiff to overcome the defense. To do that, he had to either identify closely.
And she found that he didn't overcome that burden, right?
Right,
I mean,
because he didn't respond to the argument whatsoever.
And she found that. And she didn't say, I need more factual development, I need more time, I need to kick the can down the road.
No, the sole reasoning the court provided for denying it was because the defendants did not establish something that it did not have a burden.
Well, I mean, the core reason was because defendants didn't raise the argument in the first place.
Defendants raised the argument.
No, but she said it wouldn't be fair because while defendants said qualified immunity applies here, writ large, generally, they didn't articulate the basis for the theory or the legal basis for the defense with regard to Mr. Woida's actions in particular, right?
Well, I think that the posture, I mean, this was a motion for judgment on the pleadings. So, I mean, there was the facts that this argument was based on were in the pleadings. I mean, that we
I understand that. And Mr. Woida argued that qualified immunity should apply. Mm-hmm. I give you that. But he and Mr. Doe in conjunction said that the law was not clearly established that a bailiff couldn't speak to a juror, right? Neither of them talked about this kind of failure to intervene theory or explore it, and so I guess it's difficult for me to take the district court to task for not wanting or not addressing an argument that Mr. Woida never made before her. This kind of the failure to intervene and qualified immunity with regard to that claim.
The only allegations against Deputy Woida is this failure to intervene and failure to report. There's no other conduct that is alleged by Mr. Mahajni that Woida did or didn't do that violated his rights. I mean,
right. But but usually the way this happens is that one side raises a legal argument and gives the other side a fair opportunity to respond to it, right? Here, the district court found that Woida, while he may have raised qualified immunity generally, along with Doe with regard to the particular direct action, didn't raise this failure in context of failure to intervene, and so it wouldn't be fair to grant qualified immunity in that context because the plaintiff wasn't given a chance to respond. I mean, that's what the district court said when it talked about fairness, right?
it did say that, but
Wasn't the plaintiff's theory failure to intervene? The plaintiff filed the complaint, right? Not the defendant.
correct. And the argument
So
that
what
we
else
raised,
could qualified immunity have applied to if it wasn't failure to intervene? That's the plaintiff alleged that the defendant failed to intervene. What else could qualified immunity have been about? Fourth Amendment, original spirit? I don't know.
there was nothing else, which is, when we raised the argument in our briefing, it was the alleged conduct of Deputy Woida did not violate a clearly established right. There's no case law that requires
Meaning
a defendant
his
to show...
allegations, right?
Correct.
His allegations from the complaint.
Correct. And there's no case law that
All the district judge had to do was read the complaint.
Correct. As did Mr. Mahajni, because I know that some of his arguments were that there was nothing for him to respond to. But I mean, the issue was put forth at that point. It became his burden. There's no case law that requires anything further from a defendant for immunity to be recognized. It's the plaintiff's burden to overcome that defense, and he did not respond to the defense at all with Deputy Woida.
All right, do you want to save some time for rebuttal here, Mr. Flood?
Okay, thank you.
All right, Mr. Curter.
Good morning. May it please the court. I'm Attorney Imran Kurder. I represent Marwan Mahajni, the plaintiff appellee in this case. And Your Honor, before I get started, I would like to say I'm successor counsel. I was not there at the district court. I have the exact same access and details that was presented before you.
Will you agree that in the district court the plaintiff failed to respond to the argument of qualified immunity, right?
I would not. I would state that there was in the predecessor counsel's brief a paragraph that detailed out why qualified immunity would not apply.
All right, well, anyway, the district court found that to be insufficient. The district court found that the plaintiff did not meet its burden, right? And then in sort of some act of fairness, I suppose, denied qualified immunity. What basis in the law is there for a judge to deny qualified immunity when the plaintiff has not met its burden?
Well, Your Honor, I would argue that it gave an out to the.
And what law allows that? That's my question. What law allows the district judge to just say, I'm not going to apply the law?
I think that in terms of inherent authority, they have the discretion to say that this is not properly raised or was not properly fleshed out. The district court, in her argument, stated that while the defense had raised the issue of qualified immunity, that they made no arguments. So in terms of how the plaintiff was to respond to said defense, how it was to apply to said defendant,
was the plaintiff confused by its own allegations in the complaint? I mean, what else could it have been about?
No, I think that
it's failure. This is a failure to intervene case. It couldn't be any simpler.
I think that it's the level of action, whether for Doe, the other plaintiff, the other defendant, bailiff.
Look, why is it not this simple? The plaintiff makes allegations in complaint. The defendant says, I'm entitled to qualified immunity because there's no clearly established law that says the plaintiff's facts violate a constitutional right. That's it. Now the plaintiff has to come forward and say, no, there is established law that supports that the facts alleged in the complaint violate clearly established law. What more could the defendant have said? I suppose he could have repeated the plaintiff's complaint paragraph by paragraph.
I think that the district court allowed the option for the defendant to brief and do a reply brief allow the plaintiff to do a reply brief in regards to the specific liability of Mr. Voida, but the defense decided that they wanted to seek the remedy through the Court of Appeals, and this is a 12. It's splitting.
Wait a minute. Yeah, I understand what you're saying, but here the district court decided it. There's no doubt, and you didn't make the argument that the district court didn't decide it.
That is correct.
You did not make a jurisdictional argument. Now, you don't have to. I mean, we need to decide. But there's no doubt that the district court decided the issue here. She did not say, I need further factual development. I've got to await summary judgment to decide qualified immunity, which we see a lot, as Judge Ripple indicated. She could have said that and said, I need to kick the can down the road. She didn't.
I would agree that she did make a decision in this matter. I would.
Decision was what?
That she would deny qualified immunity without prejudice in terms of this defendant. I think
it's always without prejudice. You know, you can raise qualified immunity at the end of a trial. It's always without prejudice.
Absolutely.
But we don't have to wait till the end of the trial to decide qualified immunity. Once the district court decides it, the defendant can appeal.
Absolutely, and they've exercised their rights to do so. I would argue, though, that in the district court's discretion and how she came to her conclusion as to how qualified immunity was raised without argument, and that while I would take a contrarian opinion as to whether or not a plaintiff actually responded, she stated that this was not
She
fleshed out
stated the
argument.
plaintiffs didn't meet its burden. I mean, the defendants have certain rights, and district judges can't just willy-nilly apply the law in the way that they see fit. I mean, defendants have rights. The whole right to qualified immunity provides that they not stand trial, that they not have to go through discovery in the summary judgment process. District judges, I don't know what authority you can point to in the rules or in the law that says a district court judge can decide that the plaintiff failed to meet its burden, decide the issue of qualified immunity, but yet in some act of kindness or fairness to the plaintiff say, I'm going to allow the case to proceed.
I would point to the district court's reasoning behind where she came to her decision, which is while the defense raised the issue of qualified immunity, they made no arguments as to why Mr. Voida is entitled to that.
How would they have done that here?
I think that
Other than repeating the allegations in the complaint, it's not their burden to establish that there is no clearly established law. It's your burden to establish that there is. Once they say that we take the facts of the complaint, there is no clearly established law to support the constitutional violation, what more do they need to do?
I think it boils down to the unique nature of this case. That there's not a ton of case law in terms of.
There's none.
In terms of, well, there is one case that predecessor counsel did cite in their brief, Toby versus Bessinger, which detailed out a bailiff intercepting messages between a jury and the judge and the
Oh, no, I'm talking about procedural cases.
Yes.
I'm talking about procedural cases that say that what happened here is okay.
Do you think the if the defendants had filed a one-sentence motion for summary judgment, saying, or judgment of pleading, saying qualified immunity applies here, period, and the plaintiff responded as best the plaintiff could, and the district court said, you know what, I'll address some of these theories, but with regard to the ones that they didn't raise, I don't have to do it because that's what parties are supposed to do. The notion of party presentation is I'm not supposed to go and figure out and make theories for them. Do you think a one-line motion for judgment on the pleadings would be sufficient to satisfy a party's burden?
I would argue that there has to be some, while qualified immunity is a very strong tool in the defendant's tool bag for this case, I don't think just by stating that there is qualified immunity without stating how it applies, the procedural background, statement of facts, just the bare minimum of how this should apply to this case. They've raised the issue, but didn't, and the judge said that they raised the issue, then said that they did not make any arguments. While I'm appreciative of the one-line arguments, it would make our jobs so much more easier. I would argue that it fails to meet, like, how would then a plaintiff respond?
Well, the plaintiff would respond from the allegations in the complaint. You had one theory, failure to intervene. It couldn't be any simpler. I could accept that if there were multiple theories where the defendant would have to set forth the theories and say that the facts as alleged in the complaint, there's no reason the defendant needs to restate all the facts. The facts as alleged in the complaint do not establish this theory, or there's no clearly established law to establish this. Here it's failure to intervene. That's it. I mean, we have the complaint, we have one theory of liability, failure to intervene. Why is it not enough for the defendant to say, my client is entitled to qualified immunity? Now, plaintiff, it's your burden to qualified immunity because there is no clearly established law that that says the facts alleged in the complaint amount to a constitutional violation. Now the buck passes to the plaintiff to say, no, there is. Judge, there is a case. It's Smith versus Jones. And now it's the defendant's responsibility to respond and say Smith versus Jones is inapplicable. But it's like a tennis serve. Once they serve, what else does the defendant have to do in this particular case? Repeat the allegations in the complaint?
I would argue that while the complaint does list both Doe and Voida together, I would argue that defense has the argument to say, okay, for Doe it's crystal clear as to why the violation occurred and why qualified immunity doesn't exist. But for Voida, his
But
failure.
we're not
to-
here on Doe,
No,
right?
we're not.
We're only here on Voida.
Correct. And I would say that this is how
It's your
Voida.
complaint.
That's
It's your
correct.
complaint.
Yes. So I would argue that the defense has the ability to raise the issue in the district court, raise the issue of qualified immunity, which they did. I'm not saying that they didn't, but then to flesh it out with arguments saying, okay, this is failure. It may be a 1-page, 2-page document, but the fact that they made no arguments doesn't mean that they can just.
They did make an argument. They don't have the burden.
Well, they are the moving party. And I would argue this, again, seeing that I'm out of time, I would just finish on this thought. This is not a summary judgment motion. This is a Rule 12 motion. Splitting of hairs, but there is a different in terms of burden and in terms of responsibility. They are the moving party.
All right, thank you. Thank you very much, Mr. Carter. Mr. Flood, we'll give you a minute for rebuttal.
Thank you, Your Honors. First, I just want to address Mr. Carter's argument today that Mr. Mahajny did address Deputy White's qualified immunity in the district court. That was not the case, and his opposition to Deputy Doe's qualified immunity and his arguments that were specific to that defense do not carry his burden with respect to Deputy Woida. The district court correctly acknowledged that there are different allegations against those two defendants, and the distinct conduct that's alleged by them or against them requires a distinct analysis on qualified immunity, and that comports with the standards for individual liability under Section 1983 as well, which requires personal involvement.
Would you like to comment on this Brethard case, which we decided a little earlier in this year?
In what case?
Brethard, Beathard.
I do not have any comments on that case, Your Honor. I also wanted to address the option to brief on summary judgment and whether the court has the discretion to do that. I agree that the court has discretion to not decide a motion or to let a motion sit, but that did not happen here. The motion was decided, and qualified immunity protects government officials from both litigation and liability. So the purpose of qualified immunity is undermined if we have to wait until summary judgment to be able to argue again.
All right, thank you, Mr. Flood. The case will be
you.
taken under advisement.
Thank you.
Our next case is USA versus Sheik, appeal number 25-1011. Mr. Shivari.
Good morning, Your Honors, and may it please the Court. My name is Matthew Shivari, and I represent the appellant defendant in this case, Mr. Farhan Sheik. Would request to reserve 2 minutes of my time for rebuttal if I have it to reserve. Your Honors, what the government did here is akin to pulling a fire alarm, watching people vacate in a panic, and then using that panic as proof there was a fire. The clinic's workers' fear tells us only that the law enforcement's warning was effectively alarming, not that Mr. Sheik's posts were true threats. This is simply bootstrapping. The government created fear, then used that fear as proof. And the subsequent improper admission of testimony from the clinic's workers, an improper admission of the 11 photographs depicting the security improvements, and the district court's subsequent denial of Mr. Sheik's Rule 33 motion for a new trial was error. In understanding Mr. Sheik's actual intent is critical here, and we know that by turning to this court's 2008 decision.
Mr. Shivari, why aren't all these arguments waived? I've never quite seen a brief like the one that was filed in this case.
Understand, Judge.
4 pages of argument. Couldn't be more bare bones than that.
Couldn't
be. 3 issues and 4 pages. I don't know how you could have been more bare bones than that. Our cases overwhelmingly say if you fail to develop arguments, they're waived or forfeited. Why isn't everything here forfeited?
Judge, I would argue, especially as to this issue regarding the denial of the Rule 33 motion, that the arguments were certainly developed. This was raised during a pretrial motion, continued and renewed during trial.
No, I'm talking about in our court.
Understood, Judge.
There's no record cites, there's very little citation to case law that makes any sense with respect to your arguments. There's nothing there for us to review.
Judge, I would respectfully posit that our emphasis was on the developing the factual citations to the record that this court would need to make a determination. The case law, as the government cites, I think, provide.
You argue that the district court erred by failing to deny the indictment because the grand jury was not properly informed of essential materials, and you cite no authority or records whatsoever from the grand jury to support your arguments. None. Now that argument is over because once the jury decides a case, it makes the grand jury process unreviewable. So the argument doesn't make any sense to begin with, but you cite nothing in the grand jury that would support your argument. How can we possibly address the merits of that claim?
Judge, I think the factual record allows review of the merits of that claim. As to the denial of the Rule 33 motion.
Could I take you there with regard to the Rule 33 motion?
Yes, Judge.
So your argument is that the reactions of the clinic employees was not relevant because they didn't see the actual, they were just told there was a threat. They didn't see the actual posts. Was there any, what sort of argument, if any, was made with regard to why, if the witnesses had seen the actual posts, that they would have had some sort of different reaction?
Yes, Your Honor. I think that's why the context in which Mr. Sheik's posts were made is relevant and important, and that.
So is the FBI or these agents supposed to not only show the witnesses the post, but also tell them about the context of the posts?
Judge, I would say that the context is important, as this court made clear in U.S. v. Parr.
I understand the context is important. To figure out whether or not it was a true threat, and that's something that the jury should consider. But my question is, with regard to Rule 33 motion, you are arguing that district court abused discretion in allowing the employees of the clinic to testify, and you say that's because the testimony is irrelevant because they didn't review the posts. Their reaction was based upon law enforcement telling them that there was a threat.
To the narrow issue of relevance, I would agree.
And so my question is, in the district court, was there any argument made as to why the posts themselves would elicit a different reaction than what they got? Because it seems to me that the posts themselves, in some ways, would be more alarming than what the witnesses were told at the clinic. I mean, he goes on, says it's not a joke. He identifies the Women's AIDS Center by name and its location. He uses profanities throughout his posts. Was there any argument made about why showing them the posts would have elicited a less alarming reaction?
Judge, I think the posts, and particularly the form in which they were made, would have registered a much less alarming reaction because those posts were made in a specific forum that was built and patronized based on responding to making statements through shock value in a platform that was known for dark humor and outrageous posts. It was never...
No, I understand. But so your theory then is that in order for the employee reactions to be relevant, the law enforcement officers would have had to provide them with all of this context.
I think that would have could have potentially registered a much different level of alarm in seeing the form in which those threats were made. And that's why the facts here are distinguishable from U.S. v. Schneider, where the threats were sent directly to the Supreme Court. There's no issue there. The threats here were made in a forum designed to get reactions. Furthermore, there's no Mr. Sheik took no steps toward any attack, no weapons, no planning, no reconnaissance. It was clear, even from the government's only witness from the iFunny universe, also said that that was the nature of those type of posts, is to get a reaction.
I mean, he did say, one of the posts did say, to all the FBI agents in this app, I am not a satirical account. I post what I mean, and I will carry out what I post. I would be alarmed if law enforcement agents who saw that post didn't take it seriously. Like, how do you explain something like that in the context of this being all, kind of not a real threat?
Judge, those posts represent ongoing communication within the community of iFunny. So Mr. Sheik is simply doubling down on that kind of stance to seek reaction. Again, in that forum, there was no intent of there being a true threat. It was a forum where that would be, those types of things were exchanged without it being a true threat. Mr. Sheik, in his particular position, capitalized on another user, Army of Christ, being arrested for similar posts. This was his unfortunate opportunity to capitalize on that trend, to gain clout and popularity through that forum, which at that time, very sadly, he desperately sought. But again, that understanding of that context to the clinic workers, I think, would have registered a much different level of threat.
You want to save some time for rebuttal?
If I may, Judge, thank you.
Ms. Wells, do you have anything to add here?
Thank you, Your Honor, and may it please the court. Briefly, I do want to address the Rule 33 motion and the testimony of the clinic workers, and I just think it's important to frame the nature of the testimony and what was going on at the trial, which is, as we've heard even this morning, the entire defense in this case was that the defendant's posts were a quote-unquote joke, that they were made in a forum where no one took anything seriously, where nothing could be taken seriously. In light of that, the government presented testimony from 2 employees at the clinic that was the target of the threats. That testimony, it's difficult to tell from a written record sort of the time that goes on here, but to put it in context, there's about 20 pages total of direct testimony from these 2 witnesses. The district court instructed the government, and the government did keep that testimony concise. She instructed us not to belabor the point or introduce cumulative evidence. And what we actually see is that their testimony established a handful of key things for the government: the location of the clinic, the fact that it was a real business at the location in the threats, that it performed abortion services, among other things. In other words, all to corroborate the reasoning that the jury should find this was a true threat. And so with all of that in mind, there was nothing about their testimony that was meant to garner sympathy. There was nothing emotional about it. It's quite matter of fact. The district court has broad discretion here, as this court knows, but I do want to flag one other thing that I think is material to all of this, which is that there was a jury instruction added to the pattern, and the jury here was instructed specifically that it is ultimately for you, the jury, and not any witness, including law enforcement, but to include the clinic workers, to determine whether a reasonable observer would interpret these as true threats. And then finally, I think the court made a good point earlier that what was presented by the agent to the clinic workers in terms of describing the threat was accurate but sanitized. It was far less alarming, far less emotional, far less frightening than the actual posts themselves. And so I think the point is well taken that had the jury actually seen the posts, or excuse me, had the employees actually seen the posts, their reaction may have been even more significant. Of course, at the end of all of this, the harmless error standard applies. The evidence in this case was overwhelming. The posts themselves, just on their face, are true threats. The surrounding commentary and reaction by the defendant and the other users of iFunny corroborate that. And so if nothing else, the court can find that there was no error on that basis. Unless there are other questions, the government would ask that the district court be affirmed in all respects, and will rest on the papers.
Okay, thank you, Ms. Wells.
Thank you.
Mr. Shivari, would you like to add anything else?
Judge, as to the government's summary of the clinic worker's testimony, it was far from succinct and matter of fact. This was 2 days worth of testimony, and their testimony really formed the heart of the government's case. And it was very, certainly highly emotional. Ms. Cam, for instance, testified that she was frightened, apprehensive, uneasy, scared. The other clinic worker also testified that she was shocked and scared. Talked about, there's testimony about taking time off work, considering whether they could still work at the clinic, etc. So this, in a profound way, would have biased the jury and garnered sympathy, as well as the photographs that showed their reactions, all of which took place only after law enforcement manufactured that fear by informing them of the threats. The sanitized version, again, does remove any mention of the form in which those posts were made, which would have been relevant without, there's no way to determine if the jury would have came to the same conclusion without that testimony, for which reason we would ask that this court vacate Mr. Sheik's conviction or remand for a new trial.
All right, thank you, Mr. Shavari. The case will be taken under advisement. Our last case of the day is Ishmael versus DeJoy, appeal number 25-1412. Mr. Salabi, whenever you're ready.
Good morning, Your Honor.
Hold on for 1 second, Lynn.
Of course.
Okay, go ahead.
Good morning, Your Honor. May it please the court. I am Rayed Shalabi, and I represent Yusuf Ismail, the plaintiff appellant in this appeal matter. This case judged an individual who brought a discrimination case against the Postmaster General of the United States. Questions here are whether or not the district court erred in strictly enforcing Rule 56.1 to deem all the defendant's facts submitted while disregarding plaintiff's evidence citing his response, as well as their error in granting summary judgment on plaintiff's discrimination claims by ignoring evidence that plaintiff was subjected to adverse actions, including emergency leave, public communication, and disparative enforcement of workplace policies, as well as they rejected plaintiff's hostile work environment claim by overlooking persuasive harassment such as public discipline, COVID violations, and retaliatory scrutiny, which collectively altered plaintiff's workplace conditions. Lastly, if they improperly rejected plaintiff's retaliation claim as they misapplied Muldrow v. City of St. Louis by disregarding the full scope of adverse actions.
Mr. Shalabi, there's a host of cases where we have said that a district court in Northern District of Illinois is entitled to exercise discretion and insist on strict compliance with Local Rule 56.1.
Correct.
Why shouldn't that rule be applied here?
So in this case, the district judge, when they were looking at Rule 56.1, even based off of defendant's briefing, they went outside their briefing and said, I want to look at the record, I want to look at the full depositions. I know you didn't include it in your argument, but I still want to look at that. And the law does state that. You can look at the entire record, and if anything negates 56.1, you can use that. And the judge just failed to do that. She wanted to use it in terms of to benefit the defendant here, but didn't want to use it in terms of the plaintiff. Because even in her order, she explains specific instances of discrimination that she did believe occurred, and it did rise to the level of a basis for a claim, but said that she would not find it that way. That doesn't mean a jury fact finder wouldn't find it that way. This is a case where a jury should be able to hear those facts and go over it and not just take her opinion on it.
I think the first of all, I think the opinion that we're reviewing is Judge Kennelly's opinion, right?
Correct.
And so that's Matthew Kennelly.
I'm sorry. I said that right.
The other thing is that the rule allows the district court to look at other portions of the record, but it doesn't require a district court to do so. It can exercise discretion. And here, at least the defendant points out that the reason why he wanted to look at the full deposition of Mr. Calabrese was because he wanted to see what was in there about other comparators and about Ms. Eckler in particular, to see if there was a basis to afford the comparator argument. That seems like something that would inure to your client's benefit and not necessarily the defendant's benefit. Am I missing something?
No. Yes and no. So it would be my client's benefit they looked at the entire record. But when they looked at the entire record, they did state in their opinion that when they looked at it, they did find these instances of harassment, that things that they would meet the prongs. However, in their opinion, it wouldn't meet this prong. It's not about their opinion. It's got to be a fact finder of a jury or somebody else of a reasonable opinion. And I don't think when they looked at those facts that it was reasonable to them to infer that this discrimination didn't happen. Secondly, Your Honor, the reason why that's incorrect is because when they went outside of their motion to do that, it didn't necessarily help us. In a certain spot, it's helping the defendant provide their argument for summary judgment by saying.
Well, it didn't. I think district court, in the end, it didn't help you because district court didn't find anything in the Calabrese deposition that it thought would establish that Ms. Eckler was a substantially similar comparator.
And
so I suppose in the end, it did help the defendant, but I guess the purpose of it was to assess whether or not there was anything beyond what the plaintiff had provided to establish that point.
But even under 56.1, Judge, and cases in the appellate court have stated that on cases under 56.1 or cases where affirmative defenses are not replied to or request to admit, if you even look at the complaint, and the complaint itself negates what the defendant is putting up, and that's enough to survive summary judgment. I think we're looking at this the wrong standard. The defendant is saying, well, because we're appealing, we're at a higher standard. Not necessarily. They improperly gave the defendant their summary judgment motion, and they approved it, and that was improper. And that bar is high, Your Honor, and that bar was not satisfied. Even in their own opinion, they're citing these discrimination cases, which they said they did relate to our client. However, under their opinion, it wouldn't survive a test of a reasonable person. That's not accurate, and that's what we're appealing off of. When they look at the facts of the case, again, when you go outside that motion, you look at our complaint, you look at the depositions, you look at the discovery, it's clear that Mr. Ismail was discriminated against, and if it's not clear, then a jury should be able to decide that. I'd like to just save the rest of my time for rebuttal, if that's okay.
Terrific.
Thank you.
All right, thank you, Mr. Shalabi. Ms. Winston,
Thank you.
what do you have to add here?
May it please the court, counsel, your honors. This court should affirm the district court's ruling because no reasonable jury could conclude that Mr. Ismail was discriminated against based on his race, or that he was retaliated against or subjected to a hostile work environment. Mr. Ismail has no evidence whatsoever that he was discriminated against based on his race. He only identified one comparator, which the court has already mentioned, Deborah Eckler. However, Ms. Eckler is not a similarly situated employee because she did not have a comparable disagreement with the supervisor on the workroom floor. The district court engaged in an examination of the entire record and found that the disagreements between Deborah Eckler and Mr. Calabrese and Mr. Ismail and Mr. Calabrese were not similar. Second, the district court correctly decided that Mr. Ismail was not retaliated against, though he engaged in protected activity. That protected activity was not related to any of his protected classes. And third, the district court generously found that Mr. Ismail pleaded a hostile work environment claim. However, the event was not based on Mr. Ismail's race. And for those reasons, the court should affirm the district court's decision granting summary judgment for the Postmaster General.
Thank you, Ms. Winston. Mr. Schlabe, would you like to respond to any of that? Okay. Well, you have 4 minutes and 17 seconds. You can take as much of it as you like.
Thank you, Your Honor. What counsel's saying is inaccurate. There was several instances of discrimination against Mr. Ismail, and it was pointed out by the Postmaster General that stated that nobody in that postal service was of Middle Eastern descent, and that Mr. Ismail has been working there. He's a senior person there. He's been there for several years. And there's also facts in the case that show that this happened previously before, Your Honor, where Mr. Ismail was discriminated against. And the lower court did on summary judgment find that discrimination events did not happen, and the higher court yourselves did overturn that, and it came back down to an award for Mr. Ismail. This is a history in this U.S. Postal Service that they discriminated against Mr. Ismail, and nobody there is of Middle Eastern descent besides him. And it was noted that it doesn't have to be a direct statement of somebody's race to be discriminated against based on their race. It just has to be somebody is treated differently, and it was shown by superiors and by the union that those things did occur in this case. And for the district judge to state that they're not under the opinion that it occurred doesn't mean that that's proper. That's why we have a jury to decide these types of things. Everybody can have a difference of opinion, but for that to be flushed out on summary judgment in this case is not proper. This is not a frivolous claim. This has happened before. There were several instances that occurred here today, in this case. My client is taken out by police authority while he's doing his job for no reason at all. And they concluded, several employees concluded that's never happened to them, even though they've shouted at their bosses and there was shouting matches and some of them turned physical, and none of that stuff occurred against them. It's not one incident, it's not two, it's not three, there's several instances. And Mr. Ismail, when he files a grievance, he gets retaliated against. The one time he got retaliated against, he was sent home for several weeks, and then when it came back, they determined that it was improper. They gave him his full payback, and everything was done. That alone shows proof that he's being discriminated against. The Postal Service themselves said that these things that did occur. So now when he brings a claim for a judge to state that those things are not reasonable to go to a jury, yes, they are. This was not disposed of properly at summary judgment. My client should have his time and day in court to go ahead and argue his case in front of a jury to see if they believe it was reasonable or not. This is not a defeat to the defendant. It's just giving everybody a fair opportunity to be heard in court to see who's right or wrong. And I do understand that cases should be disposed of on summary judgment, or else, courts will be backlogged. This just isn't one of them. So we're respectfully asking that you do find that our appeal is proper and reverse the decision of the district court. Thank you.
Okay, thank you, Mr. Shalabi. Thank you to both counsel. The case will be taken under advisement and the court will be in recess.